For the longest time, there was no way for a man to prove that his wife's child does not belong to him. He's not the father. And even the Indian Evidence Act made it an irrebuttable presumption of law that within the foundations of marriage, if a child has been born, then the child must belong to the father. However, the past couple of years, DNA testing, the courts, including the Supreme Court of India, started agreeing it is conclusive proof. So why not use DNA testing to establish paternity? However, the past couple of years, very recent years, there have been a U-turn now in the philosophy of the Supreme Court, and the court says we want to exercise extreme restraint before passing any orders for DNA testing. We do not want to give the tag of illegitimacy to a child. We do not want a child called bastard, and we also do not want the man to not have responsibility of taking care of the child, and therefore majority of the cases now DNA testing is not being allowed. Practically, what does this mean for you as a man? One aspect is, don't think that just because the child is not mine, you can rest assured. Neither should you think that nothing can be done. What I say is, at least get a private laboratory DNA test done. You can do that even without the consent of the mother. Use that in the court. Push forward with not just your cases and your applications rebutting the wife's maintenance cases against you, but also avail of your civil and criminal remedies in law, not just yourself, but your family members against the wife and her family members, and presumably perhaps her boyfriend, who is actually the father. If you do all of this, there is still a fighting chance for you to get success where you're able to part ways with this unfortunate situation.